The Metropolitan Police breached the rights of the organisers of the Sarah Everard vigil, High Court judges ruled. Scotland Yard came under fire for its heavy-handed response to the vigil in Clapham Common, London, last year. Images of women being pinned to the floor by male police officers sent shockwaves around the world. The Met had previously refused permission for the event to go ahead due to COVID laws. Wayne Couzens, 49, was jailed for life for raping and killing Ms. Everard, 33, after he kidnapped her as she walked home in Clapham. The Clapham Common vigil took place 3 days after Ms. Everard's body was found in a Kent woodland in March last year. The 4 women who founded Reclaim These Streets and planned the vigil brought a legal challenge against the force over its handling of the event, which was also intended to be a protest about violence against women. They withdrew from organising the vigil after being told by the force they would face fines of £10,000 each and possible prosecution if the event went ahead. A spontaneous vigil and protest took place instead, with police making several arrests as they cracked down on the event. Jessica Lee, Anna Burley, Henna Shah and Jamie Klingler argued that decisions made by the force in advance of the planned vigil amounted to a breach of their human rights to freedom of speech and assembly. They also said the force did not assess the potential risk to public health. In a ruling on Friday, 2 senior judges upheld their claim, finding that the Met's decisions in the run-up to the event were not in accordance with the law. In a summary of the ruling, Lord Justice Warby said, the relevant decisions of the Met were to make statements at meetings, in letters, and in a press statement, to the effect that the COVID-19 regulations in force at the time meant that holding the vigil would be unlawful. Those statements interfered with the claimants' rights because each had a chilling effect and made at least some causal contribution to the decision to cancel the vigil. None of the force's decisions was in accordance with the law. The evidence showed that the force failed to perform its legal duty to consider whether the claimants might have a reasonable excuse for holding the gathering, or to conduct the fact-specific proportionality assessment required in order to perform that duty. Lawyers representing the 4 told the court at a hearing in January that notes of a Met Gold Command meeting the day before the proposed event included a statement that "we are seen as the bad guys at the moment and we don't want to aggravate this." Tom Hickman QC, representing the 4, said in written arguments, the most significant threat identified was not public health but the perceived reputational risk to the force, including in the event they were perceived to be permitting or facilitating the vigil. The Met defended the claim brought by Reclaim These Streets and argued there was no exception for protest in the coronavirus rules at the time, and that it had no obligation to assess the public health risk. Reclaim These Streets took urgent legal action the day before the planned event, seeking a High Court declaration that any ban on outdoor gatherings under the coronavirus regulations at the time was subject to the right to protest. But their request was refused, and the court also refused to make a declaration that an alleged force policy of prohibiting all protests, irrespective of the specific circumstances, was unlawful. Reacting to the new High Court ruling, campaign group Reclaim These Streets said, "Today's judgment is a victory for women. Last March, women's voices were silenced. Today's judgment conclusively shows that the police were wrong to silence us. The decisions and actions by the Met Police in the run-up to the planned vigil for Sarah Everard last year were unlawful, and the judgment sets a powerful precedent for protest rights. This case exposes the Metropolitan Police's total disregard for women's human rights to assembly and expression. It shows that the Met Police's decision-making was flawed at every single step of the process. They got the law wrong last March, and the interim judgment from Justice Holgate said as such. In a statement outside the Royal Courts of Justice on behalf of the 4 women who organized the vigil, their solicitor Theodora Middleton said, "Today's judgment is a victory for women." Last March, women's voices were silenced. Today's judgment conclusively shows that the police were wrong to silence us. The decisions and actions by the Met Police in the run-up to the planned vigil for Sarah Everard last year were unlawful, and the judgment sets a powerful precedent for protest rights. We came together 1 year and 1 day ago to organize a vigil on Clapham Common because Sarah Everard went missing from our neighborhood. We felt sad and afraid. We were angry that women still weren't safe, and we were tired of the burden to stay safe always weighing on our shoulders. Assistant Commissioner Rolfe added, "We are considering the judgment very carefully before deciding whether to appeal the court's decision." The Met is mindful that this judgment has potential implications in other circumstances for how a proportionality assessment is to be carried out when considering enforcement action. This may apply beyond policing the pandemic. Even in the context of the regulations that kept us safe during the pandemic, this may have important consequences. The Met unreservedly endorses the principle that fundamental freedoms, such as those exercised by the claimants in this case, may only be restricted where it is necessary and proportionate for a lawful purpose. Consideration of an appeal is in no way indicative that the Met do not consider such protections to be of the utmost importance. It is, however, incumbent on the Met to ensure that this judgment does not unduly inhibit its ability, and that of police forces across the country, to effectively balance competing rights in a way that is operationally deliverable.